Before we begin, let me remind everybody in court that there is an order restricting reporting of this case. The order is that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or any member of her family in connection with these proceedings. So we must all take the greatest possible care. Having said that, thank you, Mr. Harrison.
Thank you.
Sorry, it's not Mr. Harrison, Mr. Williams.
Well, my lady and my lords know that I appear in this matter on behalf of the appellant mother, along with Mr. Perkins, who appeared at the first instance and in the Court of Appeal. We've been joined by Mr. Gratian and Miss Chowdhury in this court, mainly because Mr. Perkins was walking in Patagonia when we were preparing our written case, and so we've been greatly assisted by their input.
We're extremely grateful for everybody who's involved in this case. I understand that everybody is acting pro bono, and that includes obviously the interveners, but also the parties. And we are grateful for your public-spirited assistance in attempting to enable the court to reach whatever is the correct result.
Yes, my lady, I'd certainly echo that on behalf, I think, of myself and Mr. Tyler. We've been immensely assisted, and particularly by our juniors, but by the very helpful interventions which have been filed. Mr. Tyler, of course, appears for the respondent mother, along with Miss Markham, who appeared below. They've been joined by Miriam Carrion Benitez. The interveners, the Reunite International Child Abduction Centre, they are in attendance today. Mr. Harrison has attended, albeit the court has not provided for oral representations by the interveners, but they have attended in order to assist the court if there is any matter which the court requires their input on. The second intervention is by the International Centre for Family Law Policy and Practice, the written documents submitted by Mr. Setwright, Mr. Khan, Miss Gartland and Miss Chakowry. I don't think that they have representation here at the moment. The third intervention from the Advice on Individual Rights in Europe by Miss Fottrell and Mr. Edwards. Mr. Edwards is here along with Miss Mole, the director of the centre, again to assist the court if that is required. Some further documents have been filed by the interveners in the form of additional authorities bundles, which I hope have got to the court. There was a problem with the electronic copies which were circulated to us. I'm not sure that we yet have full copies of those bundles, so I hope the court will bear with us in the event that any of those authorities do need to be referred to. My lady, my lords, in terms of the hearing, the timings are all agreed, and in the time that I have available today, what I propose to do is this morning to address the court on the parens patriae areas of the appeal. That, I think, covers the most ground and will take the longest, and I will then turn my attention to the habitual residence issue this afternoon, which in our view can be dealt with in a more summary fashion. That's not to say that we don't place equal importance on them. Perhaps I can start by saying that although the fact that this case has reached this court, and although so many high caliber legal guns have been brought to bear on it, at heart we believe that this is a case which involves a simple issue, an issue which is of fundamental importance to the child and to both mothers, but actually a simple one, and that is whether it is appropriate for a court in England and Wales to inquire into B's welfare and to make orders in respect of her. The essence of the fundamental right to access to justice. Whether that is achieved by the application of the 21st century European approach to the determination of habitual residence, or whether it is reached by the application in the 21st century of the ancient parens patriae jurisdiction, is of perhaps peripheral relevance to the appellant mother. What matters is that somebody should look into B's welfare and adjudicate upon it, given that B's two mothers are about as far apart as they possibly could be in their own appreciation of and assessment of what is in B's welfare. And given, as I will go into briefly, the history of B's life up until February of 2014, the question, or a question which we pose is, why should it not be appropriate for a court in England and Wales to inquire into and adjudicate upon B's welfare? Are there any compelling policy reasons which indicate that that would be inappropriate? The mother's case is that there is nothing, that the nature of B's life from her birth up until her departure in February 2014 meant that England was far and away the most appropriate forum in which to determine issues between the mothers over B's future. And taken together with the fact that Pakistan will not in practice offer any opportunity for a court to determine upon B's future, means that if this court doesn't say B and the mother's case should be determined in England, it will not be determined anywhere in the world. Although, as I'll come to later, perhaps Holland, with its very wide forum necessitatis jurisdiction, perhaps they could go there to litigate the issue. But why would that be appropriate when England, the country of all of their citizenship and the country where B grew up and where one of her mothers still lives, why should this court not say England should determine it? B is now 7 years and 8 months old. She was conceived through anonymous donor fertilization. She has two parental figures in her life, two mothers.
This was NHS treatment, was it not?
It was at Barts, I think it was NHS.
Well, we don't need to go into that, but the actual circumstances. It was NHS treatment, and therefore by a licensed clinic.
Yes.
And therefore, should we assume that the Human Fertilisation and Embryology Authority Code of Practice was followed?
I would assume so, given the organisation which provided the treatment. It's not in the court documents, but if the court were interested in them, there is a whole file of the records from the treatment centre, which charts the history of B's conception and birth.
And this involved counselling the couple together as a couple?
I believe so, yes, my lady.
Well, there's evidence to that effect.
Yes. Yes. I mean, the bundles themselves contain relatively limited evidence about it, but in Appendix 3, both of the parties describe in their narrative statements the...
Well, I'm asking you that because I've read them.
Well, in that case, my lady, I
can't speak for my brothers.
For the purposes of the record, the document which is in Appendix 3 at page 412, memory stick 707, is the counselling checklist. In fact, it bears the wrong date. It should be 2007. But that is one of the many documents which chart these origins. By that time, as the court knows, the two mothers had been in a relationship for 3.5 years, and by the time B was born, they had set up a home together, they had bought a property, and B was born into a stable relationship of the two mothers. Self-evidently, if the appellant mother does not play a role in B's life, there is no replacement to do so. There is no father figure waiting in the wings. B's life story, the life that she lived from the moment she was born until her departure, was that she had two mothers in her life. And that perhaps is best demonstrated by what she chose to call her mothers. And this can be found, in fact, in the respondent mother's evidence at Appendix 3, page 373, Memory Stick 668. That B naturally, when she began to speak, called the appellant mother Mimi and the respondent mother Mama. And if there is any indication which tells us how B saw the appellant mother and continued to see the appellant mother, perhaps that best illustrates it. Whilst they were together, she plainly was accepted by the respondent mother as a mother as well, because one sees the Mother's Day cards at Appendix 3, page 419, Memory Stick 714. In happier times, Mum, imagine a day when you can just relax, kick back, dream, do nothing. I say imagine because we both know it's not going to happen. Dearest Mama, I can't believe how lucky I am to have you as my mama. Written by the respondent mother on behalf of B.
Have we got a date for that, Mr. Williams?
I don't think that is dated,
Very well, yeah.
my lord.
But these are all presumably before the breakup.
Yes, they are, of course, in happier times, my lord. In the last written communication that B sent to the appellant mother, which appears, I think, just a couple of pages later in Appendix 3 at page 429, Memory Stick 724, and this we do have a date for, this is December 2013. So after the appellant mother has...
December 2013, did you?
December 2013, yes, my lord. So the appellant mother had written in October 2013 asking to reach an agreement as to the shared care of B, hoping to avoid court proceedings. In December, we see B writing to Mimi, I missed you so much, love, B. I think she had just returned from a holiday then. And in her last face-to-face contact with her mother in January, she told her mother that her other mother had said they were going to move and that the appellant mother would never find them, and she was anxious about that. Although an issue has been raised in this appeal about the proper identification of the appellant mother, whether a declaration should have been made that the appellant mother was the psychological parent of B. perhaps it may assist courts sometimes to identify individuals in that way, but on the facts of this case, we would say that it was self-evident, beyond any real challenge, that the appellant mother and B were in a mother-daughter relationship. For B, almost certainly the legal status or label applied to the appellant mother is utterly irrelevant. What she had experienced over the course of her life was a mother raising her, contributing to her welfare, looking after her, all of the things that a parent does.
Is one looking at the question of psychological parenthood from the point of view of the child or the psychological parent? I mean, obviously there's an overlap on the factual investigation involved, but from whose point of view is one seeking to answer the question?
Well, if I may, it may depend on the particular issue which one is looking at. If one, for instance, were looking at it in the context of habitual residence, one might be looking at it very much from the position of the child and the significance of that figure in her life. If it's a parent, it is likely to lead to her being more difficult to uproot from a country where her mother is. If one is looking at it from parens patriae.
But if the question is, who is a parent, who is, in your words, a psychological parent, then from which point of view does one look at it? From both, perhaps? I don't know.
I think from both, my lord. Again, it may depend on the context where it becomes more or less relevant, but
the concept, as I understand it, and everybody will tell me if I am wrong about this, from the literature, is that the relationship of supplying an infant's basic needs results in the infant becoming attached to the parent who does that, and the parent becoming bonded to the child who does that. So it's a mutual relationship,
yes.
Experienced obviously differently between the two, because one's an infant and one's an adult.
yes.
But that's how I understand the literature, but people will tell me if I'm wrong about that.
My lady, I think I would agree with that summary.
So it is a mutual thing.
It is mutual. How it sounds, of course, in the legal matrix which one is applying may differ according to what point one is looking at. But I suppose one of the central arguments that we put forward on behalf of the appellant mother in relation to habitual residence, in relation to parens patriae, in relation to issues of parenthood is surely one has to look at the individual facts of the case and to look at the real world effects rather than to look at theoretical possibilities. And for this little girl, the reality is she regarded the appellant mother as her mother, quite naturally. And so, if that is the nature of the relationship between them, this case ultimately then is about the right of a mother and a daughter to have a court inquire into and determine B's welfare. Should she return to live in England? Should she share her childhood with two mothers? Should there be some other alternative arrangement which will best promote her welfare as she grows from childhood into adolescence and ultimately to womanhood? And if past performance is an indicator of likely future performance, the sad reality of this case, as in so many other parental separation cases, is that the appellant mother has not been promoted as another parent in B's life by the respondent mother. And if this court doesn't say an inquiry can take place in England and Wales, then no court anywhere will. And B will be probably find herself in the situation that Lady Justice Black identified in the Court of Appeal, that that situation will result in the attenuation or loss of B's relationship with the mother, because we know from the history that the respondent mother moved in 2014 without telling the appellant mother where she was going. We don't know B's precise whereabouts. It was only when the proceedings were served on the respondent mother's family in May that it was revealed that in fact B had been taken to Pakistan. We know that there was no contact at all from January 2014 until July 2014, when just before the first hearing in front of Mrs. Justice Hogg, a telephone call took place, and we know that very little contact has taken place since. The only time it took place with any degree of regularity was the 4 months between January 2015 and May 2015, when the matter was live in the Court of Appeal, when we had invited the Court of Appeal to consider joining B, and when the matter was due back for final determination in May. And of course, the Court knows that throughout this litigation, the respondent mother has denied B's right and to call the appellant her mother, or the appellant's right to be identified as B's mother. So that is the track record so far, and we know so far no welfare investigation has taken place, no welfare evidence was heard. There was an order early on that CAFCAS High Court team should seek to see B. Well, that was when the respondent mother was ordered to return to the country for the jurisdiction hearing. It was not an order that she bring B, because Mr. Justice Moylan feared that would deter her from coming. In fact, she didn't come anyway, and so Tony Jolly of the CAFCAS High Court team could not carry out any inquiry and didn't feel, given B's age, it was appropriate to interview her by phone. So there's been no welfare inquiry at all so far into what B...
Such findings of fact as Mrs. Justice Hogg made were made without an opportunity to cross-examine the respondent mother?
That took place by telephone.
Oh, it did it?
It did take place by telephone because although she applied to set aside the order for her attendance, and that came before Mr. Justice Jackson. Mr. Justice Jackson refused her application and confirmed that she must attend the final hearing, but she still did not attend. But she was cross-examined, although the parameters of the hearing in front of Mrs. Justice Hogg were very much confined to habitual residence issues. There is therefore a distinct possibility.
So is there a transcript of that?
There isn't a transcript of that evidence, my lord, no. The intervention of the International Centre for Family Law Policy and Practice sets out in some detail the results of Professor Freeman's research, in particular the long-term effects of child abduction. And it's interesting in that she draws also on research in relation to relocation cases and finds that there is a symmetry between the feelings of loss that a child may experience in relocation and the feelings the child may experience following a peremptory removal in an abduction context. And if there isn't a hearing in England, and if there isn't a determination of B's rights to see her mother and her mother's rights to see and have a relationship with her, the consequences identified in that research should not be underestimated, and that with individuals describing their lives as being a personal holocaust because of the long-term separation from another parent figure. and 75% of children having suffered serious mental health consequences.
I think we might have to bear in mind the rather limited nature of the samples in those two projects.
Yes, I know that Professor Freeman herself identifies that limitation, but insofar as that research chimes with our earlier research, and insofar as it can provide any window into the possible consequences for B of being left without any court determining what relationship she should have with her mother. At the extreme end of the range, there are very serious health issues which may arise. And of course, for the children, they talk not about the legality of what happened, the legal rights of their other parent, or the legality of their move. They talk about the day-to-day, real-life impact on them of separation from their other parent. In a different context, Lord Hailsham said when introducing the Child Abduction and Custody Act, he said this: the mere fact of abduction must almost always prejudice the child's welfare. He may be uprooted from a stable family life, he may be uprooted from school and friends, and he may be taken to a country which has an alien culture and a different language and with which he has little or no connection. And we pose the question, how opposite is that actually to what happened to be in February 2014? All of those features can be found in what happened in the respondent mother's, albeit lawful decision, but her decision to remove B to Pakistan. If I can turn to why we say in very summary form the Court of Appeal was wrong and the route to a remedy to this. The summit, the goal is an inquiry into B's welfare and then subsequently a determination of what the relationship should be. And there are two routes to that summit. One, the old and somewhat convoluted route of the parens patriae jurisdiction, although we say, I hope we will in the course of this morning make clear that actually that ought to be much simpler than it at first appears, and it should be a more simple process than that which has caused the Court of Appeal so much anxiety. And the second route, of course, is what should be the modern and supposedly simple to apply European test of habitual residence. Either will result in some form of inquiry in this jurisdiction. In our submissions, and I'll elaborate on them, we suggest that, in particular in relation to the parens patriae, some further explanation from this court would seem to be of assistance, because the Court of Appeal certainly did not think that this court had signalled any change when it adjudicated in the case of A&A. And we also say that perhaps some further assistance would be welcome from this court on the issue in particular of the loss of habitual residence, which was what troubled Mrs. Justice Hogg. And in summary, we say that Mrs. Justice Hogg did not apply the proper principles to the facts. I'll turn to it in detail this afternoon, but when one looks at her judgment, we say the structure, content and language demonstrate that in fact her assessment was essentially grounded in the third and fourth propositions of Lord Brandon in Re J. They dominate the judgment, they dominate her language, they dominate the questions she poses for herself. And she does not refer, if there is, as it were, a modern equivalent of Lord Brandon's summary of the approach to the loss of habitual residence, Mrs. Justice Hogg did not refer to this court's summary given in the case of LC, primarily by my Lady Justice Hale at paragraph 60 to 64 of that judgment, but also by my Lord Wilson. That doesn't feature in her judgment, and so we say on analysis her approach was simply wrong. Her conclusion was put in these terms: B's wish to remain in touch with the applicant does not justify making or continuing an individual habitual residence in this country when the mother has abandoned her own. Language redolent of Lord Brandon's third proposition of losing habitual residence if you leave a country with a settled intention not to return, and redolent of the fourth proposition of B's habitual residence being essentially derivative of the mother's. And if she had applied what this court advocated, namely a comparative exercise, looking back to the past as well as the future, looking at the objective and subjective markers of habitual residence, making sure that one assesses the child separately from the parent, then she would have taken into consideration many more factors than she did and probably would have reached a different conclusion. And of course, if one looks at if one views habitual residence as being an indicator or pointer to the court which is best placed to determine the future of the child, that surely is the underlying rationale for using habitual residence as the primary jurisdictional foundation. If one inverts the question and asks, well, to what extent can one identify an appropriate jurisdiction and say, does that inform where the habitual residence of the child is? As in this case, the plain and obvious forum was England, because language, culture, family, evidence, all of those matters were in England. And so as a cross-check, the determination that
Be habitually resident in two places.
No, not under the current European scheme. For children anyway. For adults, I think the question may still be a live one, but not for children.
It's difficult though, isn't it? What about
It's
those?
not obvious to me that the answer should be no. I don't see why you shouldn't have two habitual residences.
Well, of course, in a sense, one is overlaying what is supposed to be a factual determination with a legal gloss, because my Lord rightly notes a child could have some degree of integration in two countries, but the scheme of the Brussels 2A regulation, and confirmed by this court in the A&A case in 2013, is that essentially means that a child can only have one habitual residence at any one time. To hold otherwise would result in a potential conflict of jurisdictions between the two habitual residence jurisdictions. And
Is habitual residence relevant only in the context of arguments about rival possible jurisdictions? Am I right to assume that jurisdiction would exist in the United Kingdom by virtue of simple presence?
Yes.
Even without habitual residence here?
It can do, yes.
Do we know what the position in Pakistan on that particular point is?
The basis of jurisdiction in Pakistan? Yes. No, we don't, my Lord. I think we've perhaps not inquired into that because the evidence...
Now, I understand the evidence that there wouldn't be a fair determination of the issues there.
Yes.
But as a matter of formal jurisdiction, do we know what the position is on the assumption that habitual residence has not been established yet in Pakistan?
I don't know the answer to that, my Lord. It's certainly something we can make inquiries into.
You can be have you got to be habitually resident somewhere, or can you be not habitually resident anywhere?
You can be not habitually resident anywhere. That's, I think it's a particular point that Reunite are anxious about in terms of anti-abduction, the anti-abduction framework, that children who are without a habitual residence anywhere may not then benefit from the protection of the Hague Convention and other protection, and thus their position is based on what they draw from the European authorities, that in most cases there will be a seamless transition from one country of habitual residence to another, like a seesaw. As one moves from one habitual residence to another, once it gets to a tipping point and it falls into the other country of habitual residence.
As I understand it, the traditional understanding per Lord Brandon has been that habitual residence can be quite easily lost, but is harder to acquire, and that is being called into question in the light of the certainly Brussels II and the Mercury type of decision.
Yes.
Because if the badge of habitual residence is social connection, etc., then that may not be lost quite so swiftly, simply because the parent with primary care makes a unilateral decision and takes the child away. There isn't necessarily a light bulb moment for the child, whatever may be the position for the primary carer, so that habitual residence is lost at that instant. That, as I understand, is the issue.
That's right, my lord. Exactly so. The previous formulations in Shah and Lord Brandon's formulation laid very great weight indeed on parental intent. And if one looks at Lord Brandon's third proposition, it is talking about leaving a country with a settled intention not to return being enough to terminate your habitual residence. That is not, we would say, the correct approach now, because, as this court has identified, in looking at habitual residence, one is looking at objective markers: home, school, presence of relatives, culture perhaps, and also subjective markers. And of course and one is looking at integration, and the process of deintegration means withdrawing all of those roots until one reaches a stage when one can say clearly that the previous integration has ceased. In most cases, that process of deintegrating in England, in this case, would probably be accompanied by a process of putting down roots in the other country.
And are we only looking at one moment? That's to say, the moment of the relevant proceedings are commenced.
Yes.
And its only relevance is jurisdiction.
Yes. So the
that
13th...
itself is somewhat bizarre, one might think. So there we are.
That is the system we've
got. I see.
We have, yes. And so the 13th of February, 10 days after B left.
So only one country can only one jurisdiction can be the correct one.
It is.
Because you can't have more than one habitual residence.
No, you could have it.
You have to find the most habitual one, and then you have to find out what it was on that particular day. And that's all there is to it. Well, I say all there is to it. So it's quite a complex problem, but I mean, that's a sort of typical European community approach to jurisdiction.
Because under European law,
have these daft rules.
Under European law, the courts of the member state from which the child has gone retain a 3-month residual jurisdiction, don't they?
Following a lawful move, they retain a 3-month jurisdiction over contact matters.
Only
yeah.
over contact.
Yes.
I'm a little bit troubled that you told us you were going to spend this morning on the
Yes.
on the other point rather than habitual but you have taken yourself to habitual residence. Do you want to reverse the order of your submissions, or are you, and carry on with habitual residence, or?
No, let me refocus and go back to the parens patriae issue. I was aiming, but as I ever do, expanded too much. I was aiming to give a summary of what why we said Mrs. Justice Hogg was wrong.
It's always dangerous, Mr. Williams, because you get sidetracked down the details of your summary.
It is. Let me turn to the parens patriae, because that boiled down essentially to 2 points that the Court of Appeal and Mrs. Justice Hogg relied on. They categorised the applications that the mother had made as being at heart contact, notwithstanding that the application under the inherent jurisdiction was for B to be made a ward of court and for B to be returned to this jurisdiction, and that the other applications which had preceded that were for a shared residence order to implement a shared care arrangement, the effect of which would also have been to give the appellant mother parental responsibility for B, but notwithstanding that, this was characterised as at heart one of contact, and that therefore it fell foul of the jurisdictional scheme under the Family Law Act. You can't use the nationality jurisdiction for contact applications, and so we were outside the ambit of the Family Law Act. We say that simply was wrong. However one looks at the applications, if one looks behind that at the issues, this was not a question only of contact.
Now, this is obviously a matter of critical importance. Are you going to develop that now or later?
I'll come back to that again, my lord, in just a moment. The second area where we say the Court of Appeal and Mrs. Justice Hogg were in fact wrong was that they applied a very high threshold for the use of the parens patriae jurisdiction, saying that the welfare issues engaged had to be of exceptional gravity in order to use the parens patriae jurisdiction. And we say that was a misunderstanding of all of the historical jurisprudence, but most importantly, a misunderstanding of this court's decision in A&A. What the parens patriae is about, and what this court, we say, was saying in A&A, was one has to look at whether it is appropriate to exercise the jurisdiction, having regard to the other possible jurisdictions which might be in play, having regard to the ability to enforce, having regard to the particular facts of the case as to whether it is appropriate to exercise that jurisdiction. And I'll elaborate on that by reference to...
And this depends upon nationality, does it?
Yes, it does. And again, I'll elaborate on that point as well, because that seems to in itself have become an additional hurdle to the exercise of that jurisdiction.
I thought it was a necessary requirement.
It's a necessary requirement, but it is no more than that, I suppose, is the point that we make. It seems over the years that courts, particularly at first instance, have, as it were, become afraid of the nationality jurisdiction, as if somehow it is a dangerous implement in their toolbox, which needs to be handled with care. And we hope that we can illustrate that nationality is not esoteric, as Lord Justice Thorpe once described it, but actually is a default residual jurisdiction in many countries across the world, and as well as featuring in the European scheme.
But in terms of pure jurisdiction, all you'd have to establish is nationality.
Yes.
Is that right? Even
Absolutely.
if you're arguing about whether or not the welfare of the child will be better in Pakistan or Bangladesh or Australia.
Yes.
And there's no question of the child ever coming to England. As a matter of jurisdiction, the court would have that jurisdiction.
Yes, that's right. What this case is not about, in the sense of the parens patriae, is whether the court has jurisdiction. It does. And
whether it should exercise it.
It's whether to exercise it or not, which is why we say that one, however one looks at it, one actually comes back to largely forum questions.
I mean, presumably the court would only exercise the jurisdiction if it had the underlying merits or the underlying facts had something at least to do with the United Kingdom.
Yes, and perhaps I can elaborate on that. And hopefully, through one of these routes, the appellant mother asked this court to accept that B was habitually resident and that there should be a full welfare inquiry into all of the orders that she seeks. If not, then she hopes also that the court will accept that it should exercise the parens patriae jurisdiction, either to order B's immediate return, or if not, to ensure that a welfare inquiry takes place to put another court in a position to make a more fully informed decision as to whether or not to order B's return to England.
If you get to the second point, which is the point you've just been identifying, the fact, if it be so, that the matter couldn't effectively be adjudicated in Pakistan would be a very powerful reason, would it not, for courts of this country accepting jurisdiction.
Yes.
But that doesn't get over the first issue, which is the provisions of the FLA,
No.
which the courts below thought fatal to the attempt to use that route.
Yes, that's right, my lord. If in fact we've made a contact application and are barred by section 1 and 2 of the Family Law Act, that's it, we're done for.
So you are hoping for the exercise of the parens patriae jurisdiction, either to secure an immediate order for return or an inquiry into whether there should be a later order for return.
My lord, yes.
So in any event, what you want, either immediately or ultimately, is an order for return.
Yes.
Then what's going to happen?
Then the court, either prior to the return, if there is a fuller welfare investigation, will order that that return should be on a permanent basis, or if it makes a summary return order, it will then inquire further into B's welfare and will decide whether or not B should remain in the jurisdiction permanently or not.
So there's an order for return and it's complied with, and B is back in England and Wales. Can you then chart the likely progress of the issues? Would there be a further application founded on B's presence in England and Wales?
We don't believe that would be necessary, because within the inherent jurisdiction application for her return, the court can consider all of the welfare factors which would cover the short, medium and long term.
But can the court consider all that without a return?
Not within the parents.
Under the parens patriae jurisdiction, an actual return is a condition precedent, is it, to the exercise of the jurisdiction or not?
Well, the parens patriae, the orders that the court can make under the parens patriae are ring-fenced by the operation of the Family Law Act, because the Family Law Act precludes the making of orders for custody, for contact, for education, unless the child is habitually resident or present here. So those orders can't be made just based on the nationality jurisdiction, but all of the remainder of the wardship jurisdiction, including in particular orders as to which country the child should live in, are not excluded by the operation of the Family Law Act. So the court could order that B was to return to live in England. That would be a perfectly legitimate use of the parens patriae jurisdiction. Of course, at some point, if that order were made,
then in no time at all the child would be habitually resident in England.
well, the child would become present, obviously, upon landing, and that notionally at least would create another potential jurisdiction, and in due course the child would become habitually resident, and that would create another jurisdiction. But that's not as it were, the primary aim of the appellant mother anyway. It's not the primary purpose of the order for return. The order for return is sought because she wants B to live in this country.
Well, yes, but
She didn't want her to be removed.
she surely, I mean, for B to be living in England and Wales doesn't really solve your client's, or meet your client's aspirations. Wouldn't she be wanting to press before the court her shared residence application, and if not, at least, please, my lord, an order for contact? So wouldn't she be wanting to do that? And if she wanted to do that, wouldn't she have to do that by issuing a new application based upon the new presence of B back here?
She might have to do that, yes, my lord.
Now, if that then leads on to consideration whether what she's really trying to do is to circumvent the provisions of the Act itself being now nearly 30 years old, can you help at all as to what the underlying purpose of those statutory provisions in 1986 were, in order to see whether what your client is seeking to do is in truth a circumvention of Parliament's purpose?
Well, of course, they can be traced back to the Law Commission paper 138, I think, which we have extracts in the authorities' bundles of. Of course, the primary aim of the Law Commission 138 was to rationalise the intra-UK jurisdictions, given that one of the authors of the report is on the panel. I'll be corrected if I misstate any part of this, but I think the primary purpose was to rationalise the intra-UK jurisdiction and as a consequence and as a byproduct, perhaps to also define the international jurisdiction.
Where do we find the relevant provision
The
in the Family Law Act?
the Family Law Act is in Volume 1,
Tab 5.
Tab 5,
Section.
and if one's looking at the parens patriae, one's looking at Section 1.1d, which defines a Part 1 order as being an order made by a court in England and Wales in the exercise of the inherent jurisdiction of the High Court with respect to children, so far as it gives care of a child to any person or provides for contact with or the education of a child, but excluding, etc. And then Section 2, subsection 3, at MS 848, a court in England and Wales shall not make a Section 1.1d order unless it has jurisdiction under the Council regulation, or neither the Council regulation nor the Hague Convention applies, but the condition in Section 3 of this Act is satisfied. And Section 3, the Section 3 condition is habitual residence in England and Wales, or presence in England and Wales, and not habitually resident in any other part of the UK.
I think we should point out that the Hague Convention there referred to in Section 2, subsection 3, is the 1996
Yes.
Hague Convention,
Yes.
not the 1980 Child Abduction Convention.
I see that the Law Commission's paper that you've referred to was a joint paper of the two commissions.
Yes, it was.
The Act itself doesn't appear to have been a Law Commission bill, was it?
Oh, it was.
It was, because do we have the report with the bill as put forward and explained by the Commission?
No, we only have very limited extracts of the Law Commission paper.
It is a very long report.
Right.
And
Right.
when you attribute authorship to me, Mr. Williams, look at the date of the report and bear in mind that I joined the Commission at the beginning of May of 1984. So most of the policy had been decided before I joined the Commission. However, lots of loose ends required to be tied up before that.
Yes.
But I think it is fair to say, but again I'll be corrected if I'm wrong, that the major point of the report was to do a treaty between the Scots and the English and Welsh jurisdictions as to the recognition and enforcement of others' orders relating to the custody of and access to children. And the general rules as to jurisdiction were a byproduct of that. I think that's a fair summary, but people can discover if my recollection, which after all we are talking a long time ago now, is incorrect.
Certainly my recent only partial reading of the Law Commission paper would suggest that must be right. And the Law Commission dealt with the issue of the wardship and parens patriae jurisdiction at paragraph 1.25, the second page. It's just behind the royal the seal.
So which page is that?
It's at MS 1278, my lord. It's tab 23 of volume 2 of the authorities. If one takes from the top of page MS 1278, page 10, internal page 10, our scheme of jurisdiction does not, however, deal with the problem of wardship jurisdiction in relation to the residual category of orders, which, although they may relate to the person of the child, fall outside our mutually agreed definition of custody order. So the order for return would fall into that. The Scottish Law Commission regards this as unsatisfactory, particularly because orders restricting the removal of wards from England and Wales or Northern Ireland would continue to be capable of being made on the basis of unchanged grounds of jurisdiction, even if the child concerned were habitually resident in Scotland and there were no emergency. And the Law Commission is of the opinion that a review of the wardship jurisdiction beyond the core areas of care and control, access and education would require further consultation and could not now be undertaken in this exercise without causing unacceptable delay.
I think I can recall and report that there were no specialist family lawyers involved at the outset of this exercise in England and Wales. And the Scots were horrified to learn of the extent of the wardship jurisdiction, and in particular that on an application to make a child a ward of court, there was an instant prohibition of removing the child from the jurisdiction. The one automatic thing that happens if you make a child a ward of court. And the Scots were horrified that the English courts could make a Scottish child stay in England.
Yes, and I think the Law Commission...
That's behind that paragraph.
Yes, and I think the Law Commission recommended that automatic prohibition be removed, but in fact it wasn't adopted by Parliament and never has been. And within the later review of law relating to children, which led to the Children Act, although some further restrictions were placed on the wardship jurisdiction insofar as local authorities in particular were concerned, no further restrictions were placed on private law orders. And so it's clear from the Law Commission report and from the Act itself, and indeed from this court's decision in A&A, that the ability of the courts to make a return order in respect of a child was not affected by the Family Law Act. And if I return to my Lord's point of what lay behind all of this, the applications which the mother issued and the reasons why she sought those orders if one looks first of all at the applications, the first application that was issued is at Appendix 3, page 427. So this was the MS page 563.
Am I right in thinking that in her third statement she says quite a lot about her anxieties in relation to the child being in Pakistan?
Yes, but by the time the statements were made, it had become clear that B had been removed to Pakistan, and the mother's anxieties, so of course they don't appear on the first application, which was issued on the 13th of February, because at that point, although she had received the letter, which one sees a few pages further on at page 300 or MS 595.
I suppose what I'm really asking is this: if one's posing the question, what's this really all about? Do we get any pointer to the answer from her third statement?
Well, you get a number of pointers from her statements that it is about a number of strands of concern relating to B being removed to Pakistan at her. At her first statement at page 366 in Appendix 3.
What, MS 366?
No, this was internal 366, MS 661, my lord. At paragraph 6, one sees the appellant mother set out her concerns, the break in contact with all of the family, the grandparents, the cousins, and herself. I'm worried about the effect that the loss of such close family and support network is having on B, and how isolated and lonely she must be.
The wider family in this case is the respondent's mother, who's ill, the respondent's father, the respondent's brother, the respondent's sister, the respondent's other sister, the appellant's mother.
Also the cousins within that side.
Okay, and the appellant's father. So forgetting cousins, you've got 7 members of the wider family.
Yes.
Still in England?
Yes, all of the close family are in
Very well.
The relatives that the respondent mother has in Pakistan are more distant relatives. My lord, also the concern about B remaining in Pakistan is to do with the attenuation of the relationship between the two. That's set out at paragraph 8, that even whilst in England, the respondent mother was not supportive of contact, and if B was to remain in Pakistan, that would be magnified. And at paragraph 9, she sets out her concerns that B's origins, coming from a same-sex family, and the fact that the respondent mother was a lesbian, would expose B to dangers herself, and the evidence which was then put before the Court of Appeal, and which is elaborated upon by the International Centre for Family Law Policy and Practice, make very clear that attitudes to LGBT individuals in Pakistan do raise real issues connected with their safety and welfare. And so for the appellant mother, the reasons for seeking B's return were multiple. It was primarily, I suppose, to restore her to the country where she had been brought up, which she was familiar with, to her home, to her family, to her friends, to her school, to everything that up until that point in her life she had been accustomed to. Secondly, it was to ensure that the appellant mother and B maintained their relationship. And thirdly, it was to seek to protect B from the risks of living in a country which was and is still intolerant of the LGBT community. Whereas the respondent mother herself, in her statements, said that in order to remain safe, she has to deny her sexuality and live a life which is not that which she lived in England. So that was what lay beneath the application for the return. The actual wardship application, which was made, appears at MS page 608, volume 3 of the appendix, page 313. And so an order was sought to make the award for the summary return and further orders, short service, and insofar as it sheds any further light on the motivations behind it, page MS 613, in box 4, final paragraph, the applicant seeks a summary return of her daughter under the inherent jurisdiction. She's concerned about B's welfare, having been removed from England and Wales and taken to Pakistan. A return to England and Wales would also facilitate contact with her daughter. So in law, the application was...
So it's perfectly permissible, is it, to do these things by stages, to make a parents patriae application, having two reasons for it. One, if you like, the welfare of the child anyway, for the reasons given. But secondly, perhaps a natural requirement for contact. And once you get the child back again, then you're okay under the other.
Yes, clearly the court could then acquire jurisdiction. I mean, if the court felt that for instance, on having ordered the return of the child, that on a summary basis, that in fact the order should have been for the child to remain living in the other country on the conclusion of the full welfare investigation, I suppose the court might decline to allow you to advance other applications which you wouldn't have been able to make but for the return. But assuming that the court concluded that the child should be living in England.
You could have a hearing of the first question without the child actually coming back.
You could, yes. Yes, that's what happened following on this court's decision in A&A, the case of the child who had been born in Pakistan, and therefore one couldn't answer the question of whether he was habitually resident in England. This court said, well, the parents patriae jurisdiction should be used to consider whether to order his return. Mrs. Justice Parker ordered his return. Whilst he remained in Pakistan, he was in due course returned along with the three siblings, and proceedings have been underway ever since in relation to both that child, over whom this court had no jurisdiction at all apart from parents patriae, along with his three siblings. And I think, in fact, a public law dimension, care orders, I think, interim care orders were made in that case in favour of a local authority because the alienation of the children from the mother was so serious. But in terms of whether this falls foul of the Family Law Act, we would say one obviously looks both to the nature of the application made, the legal nature of it, but also the substance of what was sought and why. And in this case, this was not, as the Court of Appeal ended up characterising it, and Mrs. Justice Hogg, this was not just about contact. It was never just about contact.
Well, presumably your client would prefer the child to live in this country in any event.
Absolutely, yeah.
Whatever her level of contact with the child.
Mm. Absolutely.
That's better for her.
Yes, yes. Whether it's because of the risks, that's one part of it, but that's only a part of it. It's because England is a country which can provide, the appellant mother believes, far more to Zahara, whether it's in terms of education, health, social and family environment, almost every aspect of life that can be lived. The appellant mother would want be to live it here because of opportunity. There is little, well, as far as the appellant mother can see, of course it would remain to be adjudicated upon, there is little benefit she sees to be living in Pakistan. Of course, yes, she has the advantage of being brought up in a different culture to the extent that brings benefits with it, to learning a different language. She'll be bilingual perhaps. So there are some benefits, but in almost every other aspect of Bee's life, she would want her living in England.
Is part of that to do with Bee's eventual sense of her own identity? I mean, we all know that particularly when people reach teenage adolescence, they become very concerned about their identity and want and deserve to be told things about it. This is all the studies of adopted children, of course, but it's true of everybody. And in Bee's particular case, her identity is, shall we say, unusual.
Yes.
Do paragraphs 9 and 10 of her third statement assist you in answering my lady's question? MS 679, Appendix 3, page 384.
Yes, paragraph 10 is exactly on point, my lord, thank you.
At the end of paragraph 9.
I mean, this is, well, I suppose it's one aspect of her concern about attitudes to the LGBT community in Pakistan is how is B to feel able to be or to feel at home with her identity in that country, but also how can B gain a full appreciation of her identity if she is living in that country.
And of course, one possibility is that she is told untruths about the circumstance in order to protect her.
Yes.
And in order to protect the respondent mother. One could understand why that might happen. What would be the position were she to know her situation on reaching the age of 18 as to making inquiries of the Human Fertilisation and Embryology Authority about the donor of the sperm?
That is something I confess is out with my knowledge of the legal framework, but of course is something that this is can I answer it in a slightly different way? Because one of the appellant mother's concerns is that B is going to school in Pakistan, and almost inevitably in the school playground there are discussions about what does your mum do, what does your dad do, what's your family, what does your family do. B knows that she has two mothers, and she's probably aware that that's slightly unusual. But how does she deal with that when asked? There is evidence to suggest that the respondent mother is prepared to draw B into her plans. One has B telling the appellant mother that her mama was planning on moving away and that Mimi wouldn't be able to find her. It may be that, the sad truth is that the appellant mother just doesn't know how B currently copes with it, because she has virtually no contact with it, and whether she is effectively living a lie or not. One suspects she probably is, because as the respondent mother herself acknowledges, she cannot live an open life in Pakistan because of the risks that would pose. And so if I draw all those threads together, for almost every conceivable welfare-grounded reason, the appellant mother seeks B's return to live in England, and that is fairly and squarely within the Section 11D order. As a byproduct,
that assumes, that's sought on the assumption that the respondent mother would return with her.
Well, that's the usual assumption that one would apply. It's difficult to conceive that the respondent mother would not return with her.
So effectively, this is an order that the respondent mother must abandon her plan to start a new life in Pakistan.
If after a welfare inquiry a court were to consider that it was in B's welfare interests to return to live in England, then that might require the respondent mother to make a choice, yes.
Which choice she made would, of course, be critical to the welfare of the child.
Yes, it's a problem commonly encountered in abduction cases where a parent removes a child summarily to another country and then has to face the choice of remaining without the child if the child's returned under the Hague Convention or not. It's not a problem which is uncommon in the family courts of that choice having to be made. Of course, that would have been, we accept, it would have, of course, been very much easier in July 2014. The passage of time inevitably will play some role. It may be that, in fact, B is now being older and more articulate. If her voice was heard, she would be able to say very clearly that she does not enjoy living life in Pakistan and wishes to return to live in England for all sorts of reasons. But of course, none of this is known at the moment, because none of those inquiries were made at the hearing in front of Mrs. Justice Hogg, and Kafkas had not been able to speak to B herself to find out what she might think of the situation. That I hope that covers what I planned to say about this was not a device. This was not at heart a contact case. We accept there is a potential jurisdictional byproduct of the return. That is what happened in A&A. That will always be an issue if one orders the return of a child to this jurisdiction only on the nationality jurisdiction. But one has to look at what the substance of the applications were as well as their legal form, and say whether they were in truth caught by section 11D, and whether they were being used as a device merely to acquire jurisdiction. If they aren't, in substance, only about contact, then they're not caught. Mr. Gratian was helpfully reminding me of the point that Milady raised, that post-April 2005, of course, a child who is born as a result of the process that B was born through is entitled to obtain the information about the donor through the HFEA.
How much information? That was what I was getting at. And I knew it was after this date.
It's the information which is held on the register, which would include name, address, and details of any other children conceived through through sperm donation. May I turn now away from the issue of at heart a contact application to what we say is the proper approach to the parents patriae jurisdiction. If I can first of all, as it were, deal with the negative, which is whether one should be alarmed at the use of a nationality-based jurisdiction. And we say that one shouldn't at all. Nationality is as valid a ground for jurisdiction as presence or habitual residence. It may fall in the hierarchy at perhaps the third tier, but it remains a valid basis for exercising jurisdiction because it connotes a connection with that country, and thus the potential that the courts of that country will be well placed to deal with the issues relating to that child. And its nationality as a basis of jurisdiction is found as a component within the Brussels II regulation. And if one were to look at tab 2, where of volume 1, were to look at articles 12 and 15 of the Brussels II regulation, MS page 761. Article 12, which allows prorogation of jurisdiction under Article 12(3)(a. Prorogation may take place where the child has a substantial connection with a member state, in particular by virtue of the fact that the child is a national of that member state. And if one also finds that it is in the best interests of the child.
Sorry, where's the provision to national?
It's in paragraph 3A, my lord, on page MS 761, Article 12, 3A. The child has a substantial connection with that member state, in particular by virtue of the fact that one of the holders of parental responsibility is habitually resident, or that the child is a national of that member state. One also finds it in Article 15, where again transfer of jurisdiction can take place by way of exception. The courts of a member state having jurisdiction as to the substance of the matter may, if they consider that a court of another member state with which the child has a particular connection would be better placed to hear the case, and where this is in the best interest of the child, and a particular connection is defined at paragraph 3C as the place of the child's nationality. So nationality is a feature of the European system. Nationality is also found as a residual jurisdiction in many parts of the European Union, and the Neutz report, which was an inquiry into residual jurisdiction in European Union member states at tab 24 of the second volume of Authorities, MS 1292 is the front page. But there's a table at page MS 1385 jurisdiction based on citizenship in parental responsibility cases. One sees, and I put a marker down here that the table which appears in our written case, which I drafted before I had seen this, is slightly inaccurate, and this is the table that Professor Neutz drafted, and that identifies that nationality of the child is a ground for residual jurisdiction in Austria, Belgium, Czech Republic, England, Estonia, Hungary, Ireland, Lithuania and Poland, that the nationality of the parent, it's if I have not given the reference, it's at 1385 is the table. The citizenship of either parent.
Where's your erroneous table, Mr. Williams?
Oh, my erroneous table is.
We must
let me give
make
you,
a note that it's erroneous.
It is. It is at page MS 117, paragraph 38.
Yes.
And I take entire responsibility
Very well, thank
for
you.
misinterpreting some of the replies to the questionnaire and not having read to paragraph 123 of the Neutz report.
Thank you.
So there we see many countries using nationality as a residual basis for jurisdiction, and whilst I fully...
Is that recognised by the European Union?
Well, that was the report commissioned by the European Commission, I think, on a study into residual jurisdictions. So if there's any, as it were, definitive position which sets out residual jurisdictions in the European Union, that I hope is it. I accept entirely that the expression parens patriae may be esoteric to some ears, but what I would suggest is not an accurate statement is that a nationality-based jurisdiction is esoteric. In fact, we would suggest that a jurisdiction based on nationality is commonplace. What one has to be cautious of when exercising a nationality-based jurisdiction, though, is one has to have an eye to the fact that in the hierarchy of jurisdictions there may also be in play a presence jurisdiction or indeed a habitual residence jurisdiction. And so if I can now turn to the historical jurisprudence, we say that plainly demonstrates that the judges in Hope and Harben and Lord Denning in PGE, what they were saying in all of those historical cases about the use of the parens patriae jurisdiction is we need to be cautious about where it is exercised because, one, we may make an order which comes into conflict with an order made by another legitimate jurisdiction, and two, we need to be careful because will our order be enforceable? And those are classic forum and comity type considerations what they are, what does not emerge from the historical jurisprudence is that the courts were looking for some exceptionally serious welfare concerns before they would exercise it. I've set out, and at pages 118 and 119, MS 118, 119, extracts from those historical cases, and rather than take my lady and my lords to the source material in the authorities, perhaps I can just make reference to what is said there. It's right to say that Lady Justice Black made reference to most of these cases, but what she did in her judgment was only to draw out that part of the judgments which emphasised that it was exceptional to exercise the parens patriae jurisdiction. What doesn't emerge from the Court of Appeal analysis is the reasons why those judges were saying what they said. And so in Hope and Hope, going back to the early stages of the parens patriae jurisdiction, there might be cases in which it would be improper that I should attempt to exercise it, as, for example, where both the parents should be abroad and there should be no property here. Though, as I've before observed, I would not even in such a case say I had no jurisdiction. I should in all probability not make an order because the parties would not be within my control and they might disobey. I should feel I was doing no good, but incurring a sort of scandal, as every court does if it attempts to make an order it has no power of enforcing. So a comity forum type concern. In re Willoughby, of course, it's only under extraordinary circumstances the court would make an order when the infant is not here and when there's no property here and when the persons who have the custody of the infant are not subject to the jurisdiction. Similar concern in re Liddell's settlement trusts. In fact, I haven't set out the extract here, but in tab 106 of the authorities, in volume 8, there also emerge the forum concerns at page MS 3345. At the foot of the page, one has Slessor, Lord Justice Slessor, saying, "It has been said that this court will not make an order which will be mere brutum fulmen, a futile threat or an empty display of force. We are not to assume that the lady will necessarily disobey the court." So again, concerns about enforcement being the reason why one exercises caution. In PGE, in each of the judgments, Lord Denning, Lord Justice Pearson and Lord Justice Russell, one has Lord Denning say the court here always retains a jurisdiction over a British subject, though it will only exercise it abroad where the circumstances clearly warrant it. I do not say the court would exercise that jurisdiction in the special circumstances of the case. I do not suggest that it would order the child to be brought back to England. The father says that in these 2 years he's settled down well in Jerusalem. The court will consider what is best for the child. Lord Justice Pearson, the jurisdiction should be sparingly exercised when the infant is abroad, even if he's of British nationality. The courts of different countries are expected to collaborate for the benefit of the infant. But there may be difficulties of enforcement, and there is the risk of conflict between an order of the English court and the order of a court of the country in which the infant is present and resident. Lord Justice Russell, whether the jurisdiction should be exercised is a totally different matter. That question is not for us. We're told that both father and son are now accepted as citizens of the Israeli Republic and that infancy proceedings are now pending there. It would be exceptional for the court here to pronounce on the matter, but this is not for us and must depend on the ultimate evidence. Harben and Harben, I've highlighted the relevant extract there, that every effort is made on all sides to ensure there should be no divergence between the line taken by this court and the line either to be taken or likely to be taken by the other court. Whether an order is made depends on the particular facts of the case, but they have to be really exceptional before an order is made. And it, perhaps of some relevance to this case, the very essence of a case being exceptional is that one is unlikely to find a precisely parallel set of facts in some other reported authority, and the absence of some specific element in previous cases which have found their way into the books does not much assist the court to decide whether the facts of the particular matter before it are or are not exceptional. And we would suggest that trying to categorise a case or to pigeonhole a case in some way is not a helpful means of exercising this jurisdiction, which is so fact-specific. And the Sandbach case makes a similar point about enforcement.
There seem to be three strands in what the Court of Appeal said in this area. One is the concern about comity, the possibility of countries reaching conflicting decisions, and the caution that an English court should exercise before taking a jurisdiction in those circumstances where the child is abroad. However, in relation to that, Court of Appeal at paragraph 52 accepted that the appellant would have no realistic opportunity to advance her claim in the Pakistani courts.
Yes.
So far as that strand is concerned, it would appear to have been accepted by the Court of Appeal that the only court which could actually determine the welfare issues was the court of this country.
Yes.
Second strand is the concern that the Brutum Fulmen concern.
Yes.
But I'm interested that they qualified that at paragraph 57 by saying that if where the child had left the jurisdiction, if there was a fear of the child being taken abroad for forced marriage or to undergo FGM or be taken to a dangerous war zone, then the court would have no hesitation at all in interfering, whether the order was likely to be effective or not. And that prompts the question, well, what consideration is it other than welfare of child which prompts the court to say, we won't make this order for fear it won't be enforced? If you'd make it where the fear is that the child's going to a war zone, why not? If the concerns are otherwise. And that brings to the third strand, which is, I think, comes across very strongly in paragraph 53 of the judgment, where effectively the court is saying, well, never mind that England is the only court which could determine these matters. Even so, the court should only exercise its parens patriae jurisdiction in a case of exceptional gravity. So that the welfare of child isn't sufficient. It's got to be sort of five-star welfare of child. I wonder where that comes from. What do you say about it?
Well, we think the answer is that it comes from their analysis of the historical cases, because if one looks at what the Court of Appeal said from paragraphs, in particular, 36 through to, well, really all the way through to 42, Lady Justice Black went through all of those old authorities which I've just gone through, and what she drew from that is the words exceptional or extraordinary circumstances. But because, in particular, in the case of Re N, I think it was, and Al Habtour, the reservations on the exercise of the nationality jurisdiction transmuted from being reservations connected with comity and enforcement into having to demonstrate dire circumstances.
Why?
Well, it's not. I confess, my lord, there's no clear pathway, if I can put it like that. If one goes from those ancient, well, say the ancient.
They're not that ancient.
No, they're 1845 through to the 1960s. No, they're not. But there's 120 years of older authorities which identified comity and forum type concerns as being the reason for caution. Even in Al Habtoor and Fotheringham, which is dealt with at paragraph 39 of the Court of Appeal judgment, in fact, in that it was a comity concern which emerges because in Al Habtoor orders had already been made by the courts in Dubai, and so for the English court then to make an order in respect of a child who was in Dubai and who was the subject of orders in Dubai, which the mother in that case had participated in, was something which was a very good reason for extreme circumspection in exercising the jurisdiction.
Where do we find Al Habtoor? Just for my notes.
Al Habtoor is tab 71, my lady, in volume 6, MS 12, no, sorry, tab 71. MS 2618, and Rien
The mother had participated in the proceedings in Dubai, hadn't she?
yes, she had.
So basically, she participated in those proceedings. There had been an order in those proceedings, and then she was seeking to use the English jurisdiction in order to overturn the result of those proceedings.
Yes.
So
What wasn't a case involving extreme welfare concerns, it was a case involving a clash of jurisdictions.
You quote from Lord Justice Thorpe in Al Habtoor your paragraph 42 and go on to refer to its inhibiting effect. Is there anywhere in your printed case really an analysis of what Al Habtoor was really about?
No, only in that context, my lord, that we were there, I think, also highlighting that in Al Habtoor there was a jurisdictional concern. And then where the expression used by Mrs. Justice Hogg in this case comes from is the case of Rien, which is dealt with at paragraph 43 of our written case and tab 113 of the authorities volumes. And this perhaps is where it most clearly emerges that we've transmuted from concerns over comity and enforcement into exceptional welfare concerns. If one goes to MS 3467, we have Lord Justice Macfarlane saying at paragraph 29, it seems to me that if the jurisdiction exists in the manner described by Mrs. Justice Hogg, then it exists in cases which are at the very extreme end of the spectrum. So Lord Justice Macfarlane expressing some doubt over the very existence of the jurisdiction, but then qualifying it by the very extreme end of the spectrum. Mrs. Justice Hogg spoke of very dire circumstances. Justify, and that of course, that expression comes from a forced marriage case, justifying what Lord Justice Thorpe in Al Habtoor was rightly concerned should be a very careful exercise of the jurisdiction if it is to be exercised at all.
I'm interested in the head note in Al Habtoor. You would divide or whatever it was.
Tab 71.
71. At MS 2619, the section starting per curiam, the courts of this jurisdiction are very slow to make orders that directly conflict with pre-existing orders in a friendly foreign state. Principle of comity requires no less, particularly so where the order is unenforceable and empty.
Yes.
Well, now, if that's a fair summary of the gist of what the court was saying, that doesn't provide any explanation for what you say is a transmutation from comity, futility-based concerns to a separate exceptionality hurdle.
No, the trail leads on, as it were, from Al Habtoor into the case of Re B, which was Mrs. Justice Hogg's own decision, the forced marriage case, which is referred to at paragraph 29 of the Rien case, which we were just looking at tab 113. I mean, it may be there's some circularity here, because we have Mrs. Justice Hogg in this case refusing to exercise the jurisdiction because of the absence of very dire circumstances, which in fact refers back to her own decision, which is the first example where we see a court saying that there have to be very dire welfare circumstances in order to exercise the jurisdiction. That need for very dire welfare circumstances then becomes embedded as a result of Lord Justice Macfarlane's decision in Rien. And in terms of practice, the family courts, after Rien in July 2012, probably most practitioners found it very hard to envisage when the parens patriae jurisdiction might be used, save for those extreme cases of forced marriage, FGM. Removal to war zones hadn't then emerged as a category. But what perhaps the profession thought had occurred in A&A, this court's decision, was that the welcome clarification had been brought to the parens patriae availability when this court looked at it, and it's in tab 65. And this court considered many of the arguments actually which have been made in this case from 63, 64, 65. Having looked at all of the historical jurisprudence through Al Habtoor, through Re B, through Rien, and Milady Baroness Hale said, in my view, there is no doubt that the jurisdiction exists. This is at page MS 2540. The question is whether it is appropriate to exercise it in the particular circumstances of the case. Well, that formulation is entirely consistent with all of the Hope and Hope, PGE, and all of those cases. The court identified the reasons why one would exercise a degree of circumspection in paragraph 64, inconsistent with and potentially disruptive of the modern trend towards habitual residence. It may encourage conflicting orders in competing jurisdictions. Using it to order the child to come here may disrupt the scheme of the 1986 Act. Issues of public international law and the determination of effective nationality. And then at 65, all of these are reasons for, as Lord Justice Thorpe put it, extreme circumspection in deciding to exercise the jurisdiction, but all must depend on the circumstances of the particular case. Now, we understood this court to, as it were, be endorsing the traditional view that the reasons for circumspection in using the jurisdiction were essentially comity and forum based, rather than there having to be exceptional welfare concerns. And this court at paragraphs Roman 1 through to 5 identified particular factors which were relevant in that case, of which...
It's not the same thing to say you've got to be extremely careful as to say you can only use it in an extremely bad case.
No, we say completely different.
Yes.
Completely different.
Well, A&A was a case of a child who had been born in Pakistan, a baby who'd been born in Pakistan, lived all his life in Pakistan, but was a British national, and the court sent the case back to Mrs. Justice Parker to decide whether to order the child to be returned.
Yes.
And she did.
Yes.
Returned is the wrong word. Brought here. Similarly, Re B, was an extraordinary case because this was a girl who was born and raised in Pakistan, was a Pakistani citizen. She was also a British citizen, and she'd never been in this country at all, and she basically ran away from home to escape a forced marriage, and the British High Commission wanted to help her.
Yes.
But decided they'd better have a court order in the UK in order to help her. And so Mrs. Justice Hogg decided that she could make one. To use that as authority for a proposition that it can only be done in that sort of dire circumstance seems strange.
We respectfully agree, my lady. What we say is that one simply needs to look at the individual circumstances of the case and to look at whether in that particular case these concerns about a clash of jurisdictions or an inability to enforce are engaged in that case. And then one needs to factor in, as I'll turn to in a moment, the interests of the child, always a feature of forum type considerations. One needs to factor in the fundamental rights of the parties which are engaged. One needs to factor in any particular features of the case itself, and in this case the most obvious being that there is no available jurisdiction which can be accessed in Pakistan. And I'll answer the question, in the circumstances of this case, is it appropriate to exercise the jurisdiction? Are we going to have a clash of jurisdictions? Well, no. I mean, that's a lack of logic in this case, that we plainly won't have a jurisdictional conflict because the Court of Appeal determined that you can't access the court in Pakistan. And so there's no prospect of an order, a conflicting order being made in Pakistan. Can it be enforced? Well, there was evidence in this case because the respondent mother retains assets in this country and all of her close family remain in this country and she has engaged in the litigation. Of course, there's a prospect of enforcing the order. And so...
What, by sequestration?
Yes. That's one. That would be one possibility. But I think if one looks at the reality of it, it's probably the family ties that she has here that would act as a disincentive for her to disobey a court order made by the courts of this country. She may never, may have very little relationship with her family again if she were to cock a snook at an English court order. So our understanding of A&A was that it was encouraging or explaining that the parens patriae could be used in those circumstances, but that is not how the Court of Appeal perceived it. Our submissions that this is what the court was saying were not accepted. It was said that we were suggesting that we were overturning 150 years of settled jurisprudence by making that suggestion, But we respectfully say that was not so. In fact, what our position was that it endorsed that 150 years of jurisprudence. The Court of Appeal also said that other reason for caution in use of the parens patriae was that the legal developments, namely the Family Law Act and the trend towards habitual residence, were reasons to restrict its use. They characterise those as legal developments which were relevant to the issue, where we say that what they omitted to take into consideration were the other legal developments which were relevant, in particular the rights of the child under the United Nations Convention to have her best interests taken into account on a matter affecting her, and they failed to take into account the Article 6 and the Article 8 rights of both B and of the appellant mother. We submit that a decision on whether to exercise jurisdiction over a child is clearly a matter which falls within the ambit of Article 3 of the United Nations Convention on the Rights of the Child. It is clearly indirectly affects the child. It may in some senses be said to directly affect the child. As it happens, within the traditional approach to forum conveniens, or the exercise of the parens patriae jurisdiction, this court itself, in the Riel case, identified the symmetry between a decision on whether to exercise the wardship jurisdiction and forum conveniens arguments. And the classic and accepted approach to forum conveniens in children cases is that of my Lord Wilson in, I think it was the M&M case, where my Lord, and it's at tab 110 in volume 8 of the authorities, at MS 3399,
Sorry, page again, please.
3399, my Lord.
Thank you very much.
And my Lord's judgment reads, Counsel agree that written in terms of the facts of this case, they are as follows. And that's the considerations on whether to exercise the jurisdiction. The burden is on the father to establish that a stay of the Sunderland proceedings is appropriate. The father must show not only that England is not the natural or appropriate forum. In assessing the appropriateness of each forum, the court must discern the forum with which the case has the more real and substantial connection. If the court were to conclude the South African forum was clearly more appropriate, it should grant a stay unless more potent factors were to drive the opposite way. And in the exercise to be conducted at D, the welfare of the girls is an important but not a paramount consideration. So in the classic exercise of a stay on forum conveniens, the welfare of the children is an important but not paramount consideration, which we say is now perhaps reflected by Article 3 of the United Nations Convention, which requires that in decisions affecting the child, it's the reference is tab 10 of volume 1, MS 949, in all actions concerning children, whether undertaken by public or private social welfare institution, courts of law, the best interests of the child shall be a primary consideration. Well, we say that they should be a primary consideration in the decision whether to exercise the parens patriae jurisdiction. It's as simple as that.
What question are you asking this court to decide? Whether to make the order or what?
The mother.
I thought we were essentially discussing jurisdiction. Now, in the case of parens patriae, we moved a step away from jurisdiction because it's conceded that there is a jurisdiction, at any rate in a formal sense. But we aren't, on the other hand, or haven't so far, the courts haven't so far conducted any kind of welfare analysis of the facts.
No.
Now, you're not asking us to do that, are you? Or are you?
Well,
And are you contemplating that you'll have won the day if you win this point? Never mind habitual residence. The habitual residence part of the case, it's contemplated, as I understand it, that there would then be some kind of welfare analysis by a court. Is that right?
yes, I mean, the welfare...
What about in the parens patriae part of the analysis?
There will have to be a welfare inquiry of some shape or form. The question that
So the
ultimate
question whether
question,
to exercise the parens patriae jurisdiction will still be open on the facts. Is that right?
yes.
I'd like to be absolutely clear what the position about this is.
Well, there are a number of courses which this court, or indeed, if it were omitted, another court could follow. A court could say, on the welfare information that is known to date, we're going to exercise the jurisdiction, and the order we're going to make is an immediate return order, because we say we should exercise it because it's appropriate, having regard to all of those forum concerns, the interests of the child, the rights of the parties, and that the actual order we should make in exercising it is to order the immediate return. I accept that there is an alternative, which is that the court says, yes, it should be exercised, but we can't decide what order should be made in the exercise of the jurisdiction.
Which course are you seeking?
Ideally, we seek an order for immediate return. We say that the history of 2 years of virtually no contact indicates that really the only option for B is for an order for return to be made.
But your basic complaint about the disposals below is that this application for the English courts to make orders about B in circumstances in which no other court will have been taken without any regard to welfare, and yet you're asking us to make an order for return after B has been there for almost 2 years without really any material relevant to welfare.
I mean, B ought to be represented on any such hearing, perhaps.
Perhaps, my Lord, I
I
accept
don't
that.
know. I know very little about these things, as you know, but
No, well, my Lord, it would...
one might have thought that.
Yes, well, my Lord, I think the International Centre raised the question of how B's voice is being heard in relation to these matters, and that it perhaps hasn't been so far. My Lord, I accept entirely that the point that my Lord makes. The first question we pose is, and the first criticism we make is that the decision not to exercise the parens patriae jurisdiction was taken on a flawed understanding of when it could be used. And then our second criticism is yes, that no welfare inquiry took place. And I accept, my Lord, that one could say there is a view that in the passage of time, what is now required is a welfare inquiry as to whether it is appropriate to make a summary order for return. The appellant mother's position is that given what has happened in the nearly 2 years since B went to Pakistan and the slow erosion.
I don't see in your case a suggestion that we should be determining these questions. I mean, do you address this point in your case?
We do, my Lord, but I
say in paragraph 126, the appellant mother seeks orders which will enable her to have B's welfare evaluated and adjudicated, which is different, isn't it, from what you've just been suggesting?
My Lord, I accept we have not expanded on that. We have
Though to be fair, you do have particularly in the second sentence.
Well, I think
The
what
second sentence could be fairly be regarded as particulars of the first sentence, strikes me as somewhat doubtful.
what we set out at paragraph 8, MS 103 to 104, I appreciate it's not a fully reasoned or reasoned application at all, is that at item 2 on page MS 104, this court should also or alternatively declare that this is an appropriate case in which to exercise the parens patriae and make an order in the exercise of that jurisdiction providing for the return of B to England, alternatively remit to the High Court for a welfare inquiry.
That's what I'd understood you were asking for,
Yes.
what you've just said.
Yes.
But,
the court perhaps faced this situation in the Riel case, the American case, where the court decided to exercise the inherent jurisdiction to order the summary return of the child to America in that case without for any further welfare inquiry, because the facts of that case appeared to cry out for return of the child to America, where the courts of America were exercising jurisdiction and making orders in respect of him, I think. And it may be that this case is a similarly clear-cut case where an immediate order for return should be made. But in deciding whether to exercise the jurisdiction, the issue, another issue which needs to be taken into account are the Article 6 and Article 8 rights of the parties, and we say they are on the facts of this case, although I know the court will later be invited to conclude that the Article 8 rights aren't engaged, but we say the facts of this case of a child being born into a stable same-sex relationship, being brought up by two mothers for 3.5 years, and the child maintaining a relationship with her Mimi for after the separation, clearly engage Article 8 rights of the child and of the appellant mother, and that those ought to feature in the consideration of whether to exercise the jurisdiction, and whether a refusal to exercise the jurisdiction will have a disproportionate impact on those rights. And in this case, the obvious answer will be that a refusal to exercise the parens patriae jurisdiction will result in no order, no inquiry, no order, and the probable loss of the mutual enjoyment of each other's company that will follow on from B remaining in Pakistan in the situation she currently lives. So that was a relevant feature. The Article 6 rights, I think, are self-evident and hardly need any further explanation by me. Article 6 is plainly engaged, and the absence of an alternative jurisdiction clearly means that a decision to decline jurisdiction in this country means no country anywhere in the world will determine the issues between these parties.
Well, the argument is that we here are giving your client her Article 6 rights.
Yes, I accept that entirely, that a decision on whether to exercise jurisdiction is providing the appellant mother with access to a court, and indeed the decision by the Court of Appeal and by Mrs. Justice Hogg were providing access to a court. But it will only be an effective access to a court if the decision on whether to exercise jurisdiction is made on proper grounds. If a decision is made which does not take into account the relevant principles, and in particular does not take account of the relevant Article 3, Article 6 and Article 8 rights of the parties, that will not itself be provision of effective access to a court. Any restrictions on access must be lawful and proportionate and take into account the relevant rights of the parties. And so the flaw in this whole case in terms of the Article 6 is that the decision is made effectively by applying a bright line rule that you have to show exceptional circumstances rather than actually a fact-specific inquiry in which all relevant components feature. If that had taken place, I wouldn't have anything to complain about. But it didn't take place.
It does seem as if Rien is the case where the concept that the jurisdiction should only be exercised in case at the extreme end of the spectrum, rather than merely after a great deal of care, first entered the jurisprudence. And I'm interested to note that it was an extempore judgment. And apart from a passing reference to Lord Denning's decision in Re P, which was described as being of historic interest only, the only cases which were cited were cases beginning with Al Habtoor.
Yes.
So it was an extempore judgment without reference to the way in which the forum and futility considerations had been looked at by courts over the years.
That's right, my lord, yes.
And introducing, it would seem, a new test of extreme gravity with really very little
Yes.
consideration.
I think that's right, my lord.
Fair summary.
It is. If I recall rightly, it was only argued on one side by.
Well, it wasn't. They didn't lack. The mother didn't lack able representation.
No.
It has to be said.
But what it did mean was that there wasn't the more nuanced consideration that might have arisen from a more in-depth.
They clearly didn't think it was necessary to reserve judgment in order to reflect on what was being said.
No. I mean, the origins of the dire circumstances do appear, as far as one can tell, to come from Mrs. Justice Hogg's own decision in the forced marriage case, which is then absorbed into Rien.
There's always a difference as well between saying this is an extremely bad case and I'm going to make the order, to this is the only type of case in which you ought to make the order.
Absolutely, my lord. Of course, the first proposition is absolutely right. It may be that in a very an extreme case, the war zone cases or an FGM case or a forced marriage case, even if you think there's a real risk of a clash with another jurisdiction, even if you think that the order may not be enforceable at all, you might go on to make the order because it is such a appalling situation in terms of welfare. But it doesn't follow, as my lord says, that is the only situation in which it can be exercised. In cases where there is no risk of a clash of jurisdiction, where there is an ability to enforce a far lower level of welfare concern, or merely the identification of an issue which needs to be determined, might be sufficient to warrant exercising the jurisdiction. If I can just touch on another point in terms of Article 6, of course, forum necessitatis is recognised as a basis of jurisdiction in some countries. Again, tab 24, the Neutz report also dealt with forum necessitatis. And at MS 1357, there is another helpful table where forum necessitatis is recognised as a valid ground of jurisdiction by statute in Austria, Belgium, Estonia, Netherlands, Portugal and Romania.
But how does that help us?
We,
So are you asking us to adopt a doctrine of...
no,
necessitatis?
I'm not going that far, my lord. What we submit is that in looking at the Article 6 issues and the forum issues, if this court is able to, or if any court is able to say, no other court anywhere in the world has jurisdiction over this child, but she is a British citizen, that in parallel with forum necessitatis suggests we should provide a jurisdiction.
In other words, it's an additional reason for invoking the jurisdiction we do have.
Yes.
That's what you're
Not
basically
a,
saying.
not a separate, no,
Yeah.
exactly, my lady. I think we've probably put it better in our written case than I just put it, but that's how we put it.
And of course, it's not precisely true, is it, to say that no other court in the world has jurisdiction.
No.
The argument you make, not without some support, is that in practice there is no other court in the world which would exercise jurisdiction in this case.
That's right. I mean, it may be, and we simply don't know, that as a matter of public policy, B's origins might lead a court in Pakistan to say it would not, indeed did not, have jurisdiction over a child conceived in such circumstances. We just don't know, but that is, I don't think that's beyond the bounds of possibility that the parties might be, the gate might be.
I suppose it can be said in relation to the parens patriae jurisdiction that it's common ground that the court has jurisdiction. The only question is whether it should exercise it or not.
Absolutely, my lord, yes.
And if the facts are that there's no other part of the place in the world where it could, an issue could be determined, then that would be a good reason for exercising the parens patriae jurisdiction in these new circumstances which hadn't existed before.
Yes.
Mr. Tyler says that just because a woman might not succeed in another jurisdiction, it doesn't follow that there isn't another jurisdiction. He says, do you have to look the whole time at likely prospects of success?
We see that, and we don't accept it for a moment. It is not, we don't complain about an inability to succeed in Pakistan. We complain that in practice we cannot bring a case before the courts in Pakistan.
There's a distinction, therefore, you draw between succeeding and, to put it colloquially, getting off the ground. Is that right?
Absolutely, my lord.
Is that's because she can't physically go to Pakistan, because the application would have to disclose her sexuality in a way that would result in her being deprived of any relief?
Yes, essentially for
The
the
latter,
reason.
is it?
Essentially for the reasons outlined by the Court of Appeal, that in making the application to the Pakistani court, she would inevitably have to disclose B's origins and the nature of the relationship, and that in itself would expose her to either, at worst, possible criminal sanctions, or B, exposure to hostility.
Do you mean her the applicant or her the...
Well, her the applicant, but also B the child. I mean, it
And
would
indeed,
be
perhaps the respondent.
Oh, absolutely, yes, my lady.
Everybody.
As I think it was conceded by the respondent mother earlier that it would be at best unwise to try to engage the Pakistani courts given the risks concerned. Although that point appears to have been, that concession appears to have been withdrawn in this appeal, but the Court of Appeal conclusions on this are clear, and we endorse those. So bringing me to the...
Could I perhaps, I realise that you have not actually researched the law in Pakistan, and one understands why. You haven't been in a position to do that, you've got enough on your plate, but nevertheless, in what circumstances might a non-parent bring proceedings about the upbringing of a child in Pakistan? Until the Children Act 1989, my recollection is that wardship was virtually the only way in which this could be done. Then some other things were introduced,
Yes.
custodianship and so on. But it was not at all easy for a person who was not recognised as a parent to bring proceedings about a child in this country until the 1989 Act.
Yes. Right.
And wardship was basically the only general jurisdiction. Now, do they have wardship in Pakistan?
I can't answer that, my lady. Certainly, it's the Court of Appeal did identify this, and I think this is the paragraph of the Court of Appeal judgment which there was one of those unfortunate typing errors which all creeps into all of our documents, where the absence of two letters completely changes the meaning
And then when you sought to correct it, you forgot to put in those 2 letters.
Well, I think it was. I'm not taking responsibility for that, but Mr. Tyler's team, yes. But it's in this exact paragraph, which is where the Court of Appeal identifies.
Which paragraph is it?
It's at paragraph 52 on MS 313. Overall unsatisfactory general though the evidence is, we are prepared to proceed on the basis that it is very unlikely, rather than likely, very unlikely that the courts in Pakistan would be prepared to recognise the appellant as having any relationship with P that would entitle her to relief. I suggested at the opening of our case that at heart this was a relatively simple issue that was engaged, and it could be viewed as simply as my Lord Clark put it, that if there is no other jurisdiction available, why would it not be appropriate for the courts of England in this particular case to exercise jurisdiction? It's certainly not going to open the floodgates. It's a relatively unique case, although of course given societal changes perhaps we will come across them more often, but it's hardly going to undermine the international structure of habitual residence, presence and nationality hierarchy. It's a fact-specific case which we say it's appropriate to exercise the parens patriae, and we set out perhaps rather presumptuously a test which might be applied by courts. It essentially mirrors the test or the approach which this court set out in A&A, but explicitly within the decision to exercise jurisdiction, we say that one should take account of the best interests of the child.
Where do you set this out?
We set this out in our written case, my lady, at paragraph 93 on MS 138, my lady.
Yes.
And all of the strands from the historic jurisprudence, this court's decision in A&A, forum conveniens, come together, we say, to the conclusion that in deciding whether to exercise parens patriae, one should look at these considerations. The best interests of the child as a primary consideration, whether England is the most appropriate forum, having regard to forum non-conveniens principles, the ability of the court to enforce its orders, the importance of the rights engaged in the application, and in particular the impact of the decision to either exercise or not exercise the jurisdiction, and whether that is a proportionate interference with the rights engaged. And of course that sort of approach I suspect finds parallels in approaches to many other sorts of decisions which affect children but which are not paramount welfare decisions, whether they are in relation to extradition or immigration or deportation. One goes through a process of weighing those sorts of considerations to answer the ultimate question, is it appropriate in this particular case to exercise the jurisdiction?
You refer in number 4 to section 2A of the Children Act. I was trying to remind myself of that. Where is it? Because in volume 1 at tab 1, I think we only have a different section
of the 1989.
I find it hard to believe amongst all the authorities that that's one we haven't got in.
Well,
Section 2A, of course, is the new presumption imported by the 2014 Act,
Yep.
that it will be in a child's interest to maintain a direct relationship with a parent.
What sort of parent?
I would have to look
well, it
to
would
see
be a
how it's
parent
defined.
within the meaning of the Children Act, which of course would now include your client automatically, almost certainly,
Yes,
but didn't at the time when the child was born.
yes. I would have to check the precise definition, my lord, but that must
Perhaps
be.
we could have a copy of section 2.
My lord, we will arrange to supplement your already voluminous papers further with that.
At least it has the advantage of being relevant.
Ouch. My lady, my lords, those.
To a point. Have you got to the end of your? You seem to
I
have
have.
timed it quite conveniently.
Unusually for me, yes.
You could say that. I couldn't possibly comment. This would be a convenient moment at which to adjourn, and we'll look forward to hearing from you again at 2:00.
Thank you, my lady.